ये अभी आई है, 11:10 पे आई है मेरे पास।
हम्म।
11:10 पे आई है मेरे पास।
मेरे पास नहीं है।
लेकिन ये रिमाइंडर मेल नहीं है, वो जो मेल आती है ना कि
हाँ
मीटिंग इन्फॉर्मेशन अपडेटेड, वही
हाँ,
है।
वही वही वही। एक्चुअली रिमाइंडर तो भेजने का ऑप्शन उस वाले में होता है। वो वेबिनार वाला पैकेज होता है ना, वो ऑप्शन उसमें होता है।
अच्छा।
इसमें यही है कि रिकरिंग मीटिंग है तो जब भी मीटिंग टाइम एडिट होगा तो सबके पास जाएगा। तो एक बार ये ड्यूरिंग द वीक कर देती है, एक बार ये लास्ट वीक से सोचा था कि मीटिंग से 1 घंटा पहले भी एडिट कर देंगे तो एक मेल सबको 1 घंटा पहले चला जाएगा।
हाँ, वो आया है। कर लो, एडमिट कर लो रिया।
सर अभी आया क्या आपके पास लिंक मोज सर? मैंने आप वो उसको ना वापस से आपको कंफर्मेशन मेल भेजा था, मतलब आप लिस्ट में तो थे ऑलरेडी।
नहीं, मेरे पास थर्सडे को जब तुमने एडिट करा था थर्सडे को तो मेल आई है।
और अभी मैं
अभी आ गई।
कंफर्मेशन मेल।
हाँ आ गई, अब आ गई। 11 बजे वाले भी आ गई, वो 11 11 वाली अब आई है मेरे पास।
रिया, एडमिट कर लो।
अभी जो मैंने भेजे थे उसमें से टेकअप करने हैं, कुछ और देखे हैं?
मीटिंग स्टार्ट हैज स्टार्टेड, पीपल हैव स्टार्टेड एंटरिंग, आई थिंक।
आई थिंक 12, इट्स 12:05, सो शुड वी स्टार्ट?
नो वन इज इन द वेटिंग रूम एज ऑफ नाउ। वी कैन स्टार्ट, आई थिंक।
जस्ट अ सेकंड। So, welcome everyone. Welcome to 21st weekly knowledge session on indirect tax by Team Anivesh. So, in today, me and Ayush are here. So, we'll just start today's session. Just give me a minute.
I'll take up the judgment then. Hello.
Okay, okay, you can
Uh,
take up.
good afternoon, everyone. Welcome to this session. First judgment, very, very interesting, surprising, shocking. I don't know the word that I should use for this judgment. Is the West Bengal High Court, in the case of Motors versus the Senior Joint Commissioner, is on the issue, the distinction between the word uh, issue or communicated. So, to give a brief background of the facts of the case, in this case, the order that was required to be issued till 30th April was somehow uploaded on the portal on 1st May, but was signed around at 11 o'clock in the night through digital signature on 30th April only. The issue is that whether the order signed on 30th April should be considered as the date of issuance of the order, or the date when it has actually been uploaded on the portal on 1st of May should be considered as the date of the order, and whether it should be considered as time barred or not. So the Honorable High Court, delving on this issue, draw the distinction between the words issue and communicated as appearing in section 73. So the judgment is on section 73, but as 74 can also be referred. I'll just read what section 73 says. So 73 1 says that when it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or whether input tax credit has been wrongly availed or utilized for reasons other than fraud, he shall serve a notice on the person chargeable with tax. Then subsection 2 says the proper officer shall issue the notice under subsection 1 at least 3 months prior to the time limit specified in subsection 10 for issuance of order. And subsection 10 says the proper officer shall issue the order under subsection 9 within 3 years from the due date of furnishing of annual returns for the financial year. So the basic distinction or the basic in the words used under 1 subsection 1 subsection 2 or subsection 10 are that whether this subsection 1 uses the word serve on the person chargeable to tax, subsection 2 uses the word issue, and then subsection 10 again uses the word issue. The argument of the taxpayer was that the appellant was that the word issue and serve should be read interchangeably and they should be given the same meaning, and when the document or the order has been uploaded on the portal should be considered as the date of the issuance or the communication, whatever it may be, and it should be deemed as time barred. But what the West Bengal High Court said in this case is that the word serve and issue has been used, uh, two words are used in this section, and the legislation by its intent has used two different words. Had the intention of the legislature to give the meaning of to these words interchangeably, that is issue means serve only, then they would have not used these two words differently under the legislature. Therefore, what has been written in the law should be read as it is, as it is the principle of taxing statutes. Nothing should be added in it. And when the word issued has been issued, therefore, under the subsection 10, if the notice has been signed on 30th April, it should be considered that has been issued on 30th April and it has only been communicated on 1st of May. Therefore, this notice was not, this order was not considered as time barred and was considered within the time limits of section 73. According to me, this is going to open floodgates of litigation, because there is not only one but numerous issues on the same topic, that notice signed on the last date and issued on the portal on the next date, on the very next date, which is considered as the time barred. Can I take the interpretation in this case that even if the notice has been digitally signed, until and unless it is issued on the, it is uploaded on the portal, it should not be considered as issued for whether it has been served or not? What should be considered actually that the notice has been issued, whether it has been digitally signed and kept with the officer in his office, or when it has been uploaded on the portal, then only it will be considered as issued. West Bengal, West Bengal High Court has given this judgment. Let's see what other high courts have to say. But according to me, this is a very risky judgment, I would say. And again, it is going to give way for a lot of litigations in the future. What your views on it?
Yes, I think I absolutely agree with what you have said, Ayush. So, when this GST came into picture, the government focused a lot on GST portal. That if the one of the major characteristics of GST is that it is completely technology driven law. And this portal, when it is designed by government, so it should, and when the officer is using this portal for communication, so then for the government to say or for the court to say that if a order is being signed on a date and if it is uploaded one day later, which is after the time limit, that should be okay. I think that argument is not at all supportive of the government own goal that the communication should be through portal. If government is saying that it should be through portal, then it should be through portal before the time limit which is given in the law. So unless
Correct.
and until a order is uploaded on the portal before the due date, that should be treated as invalid. And as you mentioned that there are a lot of judgments in that favor also. So then
I
again,
think when
these
as and when it is
judgments will.
uploaded on the portal, then only it should be considered as it is issued. Service of notice in itself is a different debate altogether, wherein where especially in Allahabad High Court and other high courts, they have said that uploading on the portal does not automatically lead to service of notice or service of order. So uploading on the portal should only be considered as the issuance of order, and only merely signing of that order, and that order is kept in the office of the that officer only should not at all be considered as issuance of notice or any order.
Agreed. Agreed.
Right. You'd like to go next?
Yes. So next we have just a second. So next we have a judgment of Supreme Court in the case. So this is regarding VAT regime in the case of Asia Sugar and Chemical Company. Uh, and Indian Sugar and General Exports versus the state of Karnataka. So, so again, this is regarding VAT, but there is a one very important principle which has been laid down in this judgment. So that is why I thought we should take it up. So in this case, what happened is this case was regarding taxability of sugar. So regarding the taxability of sugar, the government made an amendment. Uh, so in 2001. So earlier, before 2001, there was an exemption for sugar. After the 2001 amendment, the exemption was restricted to sugar produced or manufactured in India. So the litigation was before 2001. So basically the pre-amendment period. The assessee imported some sugar and sold that sugar. So the department issued a notice saying that first of all the amendment was retrospective. So even before the 2001, the entry should be read as sugar manufactured in India. So any imported sugar that should not be eligible for exemption. And secondly, there was some reference to additional duties of excise, Act 1957 in the Act. So department also took reference of that to say that that reference itself means that this means goods which are manufactured in India. Because unless and until goods are manufactured in India, excise cannot be levied. So the Supreme Court held very clearly that first of all, that reference to excise, special excise duty, that was only for the very limited purposes of identifying the commodity, but it did not incorporate any territorial jurisdiction to that entry. So we have to see the law as it is. So during the pre-amendment period, that is before 2001, all kind of sugar was exempt. Only after the 2001 that entry was amended and that exemption was curtailed. So before 2001, the exemption should be available. Retrospective exemption and retrospective removal of exemption that is allowed in law. That was also clarified by Supreme Court, but that has to be properly statutorily given. In this case, when the law has been amended prospectively, in that case, the department cannot go back and ask for, say that the exemption has been removed retrospectively. I think this principle is important in a lot of cases in GST also. So whenever any amendment, any exemption, any taxability has been, any amendment comes regarding taxability, regarding exemption. So we have to be very careful when reading the law, whether that is a prospective exemption, whether that is a retrospective exemption. So I think one very common issue which a lot of people are going to face is regarding intermediary services. So recently, the intermediary services clause got omitted in the IDST Act. So post that omission, now intermediary service will also fall under the general clause, unless they are specifically covered in some other clause. But most of the intermediary services will now go under the general clause only. But that is a retrospective amendment. Sorry, that is a prospective amendment. So it will be effective only from the date when it is notified. So all the cases who are fighting the cases for the past period, they cannot take support of this amendment. So that is what we have to keep in mind whenever we are discussing any amendment. So I think that is it.
Okay.
Any views you have, Ayush?
Uh, I think correct. The main legal principle is that the exemption entry should be read as it is, and nothing should be imported from other words which are not written in it. So yeah, I mean, no such views as such, because we have other judgments also on how to read the exemption entries, and also this is on that line only. Uh, Next judgment, okay, that I'll like to discuss is uh, this is a sister judgment in service tax. Uh, Oriental Chemical Works versus Commissioner of Central Tax. So actually, this was argued by me and Mohit only in the SysTat. So we thought of discussing it. Uh, what happened in this case was that even though it is related to service tax, but the ratio is squarely applicable under the, I think, under the GST Act as well. What happened in this case was that there were five directors in the company, five full-time directors, to whom some certain amount of salary was paid, and apart from the salary, an additional amount was paid as in the name of meeting fees. TDS under section 192 was deducted only on the amount of the salary paid, and no TDS under whatsoever section was deducted under the Income Tax Act in on the meeting fees paid to such directors. So the department came and levied reverse charge on the meeting fees paid to these directors, saying that these are the services provided by the directors to the company, which are outside the scope of employment, and therefore the company is liable to pay reverse charge on it. The ratio that the Honorable Sistat held in this case by relying on the judgments of Rentworks India, Mathan Employees, etc., Mathan Alloy, sorry, held that whole-time directors are considered as the employee of the company only, and whatever amount by whatever name is paid to them, by whatever name called is paid to them, should be considered in the course of employment only, and anything which is paid to them should not be considered outside the course of employment. Therefore, even if the TDS is deducted or not deducted under section 192, it does not matter. Whatever the amount has been paid is directly under the scope of the employment services, and therefore no RCM is payable on same. Uh, there is only one issue that I would like to discuss in this is when I come to GST, Mohit, specifically when I come to GST, there is one circular under the GST Act which says that only on the amount paid to the directors in which section under section 192 TDS has been deducted, then RCM is not payable. Otherwise, RCM would be payable. I think that is written in the circular only, nowhere in the Act. However, when I compare that to the service tax regime, there was no such circular available. Even the circulars that were available, they said that whatever the amount has been paid to the non-whole-time directors are leviable to reverse charge. There was nothing related to whole-time directors. There was a circular in 2012 issued by this Ministry of Finance only, wherein it was said that whatever the amount has been paid to non-executive directors are covered under reverse charge. But when I come specifically to GST, there is a circular which says that only the amounts which on which TDS has been deducted under 192, then only RCM will not be payable on that amount. So how good this judgment will hold under the GST regime if the same happens if the company does not deduct any TDS on the any amount that is being paid to the directors?
I think say because the provisions if we see in service tax and GST, the provisions are same.
Right.
The employer-employer relationship is same.
Hmm.
So the same reasoning should hold, and not just in the case where TDS has not been deducted,
Hmm.
even in a case where TDS has been deducted under any section other than section 192.
Hmm.
Because even that circular specifically says that if it is deducted under other than 192, then RCM is applicable.
Correct.
But I believe still if it is a whole-time director and TDS is deducted under any which section or not deducted, still the same reasoning should apply and it should be outside reverse charge under GST as well.
Correct. So we will take a view different from what is given in the circular, right? So we will have to challenge the circular on that ground that if it is a employer-employee relationship, and even if no TDS has been deducted, you cannot charge RCM on that amount. If we are able to prove employer-employee relationship,
Agree, agree.
right? Only this was the point of discussion in this judgment. That is why I took it up. You can take up the next.
Good. So next we have a judgment by Honorable Gujarat High Court in the case of Mahesh Enterprises versus the state of Gujarat. So in this case, this is I would say also slightly confusing judgment because I also got a bit confused when I was reading the facts of the judgment. So in this case, what happened is the assessee got an order against him. He filed an appeal before the First Appellate Authority, and First Appellate Authority confirmed the order passed by the original adjudicating authority. After that, the assessee filed a application before Honorable GST 80 as well. But that was beyond the 3 months timeline. So that was beyond 3 months from the date of the order. So the department started recovery proceedings, and then the case went to High Court. So High Court gave the judgment in favor of the revenue, saying that citing reference of Circular 224. So Circular 224 was issued in back in 2024 when tribunal was not constituted. So what Circular 224 said is, so before coming to Circular 224, I'll briefly give how the provision of Section 112 is worded. So earlier, Section 112 used to say that appeal has to be filed within 3 months from the date of communication of the order. But since GST tribunal was not constituted, a removal of difficulty order, I believe ninth removal of difficulties order 2019 was passed, wherein it was mentioned that uh, the date when president enters the office, president of GST 80 enters the office, 3 months from that date has to be considered as the due date. And after he enters, then for the later appeals, it will be the same date. So 3 months from date of the communication of order. Then, after that, the government amended the provision of 112 itself and said that the government will notify the due date for filing of appeals. And pursuant to that amendment, then government came out with a notification saying that the due date for all orders passed up to 31st March 2026 will be 30th June, which was then extended on 30th June, saying that for all orders passed up to 30th April, the due date will be 31st July. However, this circular 224 said that to get a stay on recovery proceedings, the assessee has to at least pay the pre-deposit amount. And citing this circular, the Honorable High Court held that since the pre-deposit was not made by the assessee within the prescribed time of 3 months, therefore, the tax recovery action which was done by a department was valid, and the assessor is not eligible for refund of that amount. Another ground which High Court said is now giving a refund of the amount will tantamount to waiver of pre-deposit. So I have a couple of observations in the reasoning adopted by the High Court. So first of all, I completely disagree with the circular because if we see the statutory scheme of filing appeal before GST 80, so it says that where the assessee files an appeal before the Honorable GST 80 before the due date, then there is a and gives the deposits the pre-deposit amount, then there is a automatic stay on the recovery proceedings. So the as per law, the requirement is only to file a appeal and give a pre-deposit before the due date of filing an appeal. What is the due date? So as per the latest position, the due date is 31st July 2026 for all the orders passed up to 30th April 2026. So as long as assessee has no filed a appeal before 31st July 2026 and made pre-deposit before 31st July 2026, then there should be an automatic stay. And since that 31st July date is in future, we have not approached yet. So let's say there is a assessee who has not yet filed the appeal or given a pre-deposit. So in that case, I believe a simple letter that I want to file an appeal before the GSTAT, that letter should also suffice. And this letter was also a reference in that circular that the assessor should give a letter to their jurisdictional authorities. But the circular imposed this additional condition that you have to also give the pay the pre-deposit amount, which I believe is completely ultra vires the provisions of the act. Because nowhere in the act it says that you have to pay the pre-deposit within 3 months, and then before due date you can file the appeal. So, the Honorable High Court did not examine the veracity of the circular itself, which I believe is a fault in the judgment, in the reasoning adopted in the judgment. And second is that if at this stage now, after recovery has been done, now if the court orders the refund, then that will tantamount to waiver of the pre-deposit requirement. So I also do not agree with this logic, because so at max what department can do is retain the 10% amount which the assessee itself says that it will have to deposit when it goes for appeal. So retain that 10% amount, at least refund the balance 90% or 80%, because at first it also the assessee would have paid 10%. So at least refund the 80% amount, and the 10% amount that should be adjusted against the pre-deposit when the assessee files the appeal. So withholding that 80% amount also till the time matter is disposed of now, that I believe is will result in unjustly denying the funds to the assessee. So any views
think
on this,
GST
Ayush?
law is governed more by circulars than by act or rules in itself. Because not only this circular, there are many other circulars which I think has laid down not clarified the law, but laid down the law. So whether it is beneficial to assessee or beneficial to department, but it has clearly laid down the law rather than clarifying the law, or you can say removing difficulties, it has created more difficulties. So this is one of such circular that was there that it imposed a mandatory condition of paying a pre-deposit first of all. Though there were many cases, I think we in our office only we filed many letters directly to the department that we will be filing the appeal, and we did not make pre-deposit, and the department agreed. They did not ask for pre-deposit as well. Particularly saying that refund should be denied because it would tantamount to waiver of pre-deposit. Another approach that the High Court have followed was that allowed the assessee to file the appeal by paying again a pre-deposit of 10% or 20%, and then ordered that within this weeks, if the assessee file appeal, then within this weeks of filing the appeal, the entire amount that was recovered should be refunded. If at all it amounts to pre-deposit of a waiver of pre-deposit, or the approach that you said that 80% of that should be allowed as refund. So I think Gujarat High Court generally gives good judgments. I mean, good interpreted judgments on the law. Uh, let's see what happens. I mean, this is the only view that I have in this. I also do not agree with this judgment at all.
I think even if you see the number of circulars,
Hmm.
so in excise regime, I believe almost 1100 circulars have been issued
Hmm.
from 1944 till date. So in 80 years, they issued somewhere around 1100 circulars. In GST, within 9 years, they have issued almost 300 circulars now. So you can see the difference.
That is what I'm saying. No, governed by circulars.
Absolutely, absolutely.
So if we are on this issue of pre-deposit, one judgment that I would like to discuss is the GST judgment, Katak bench, in the case of Manoranjan Das versus Commissioner of Odisha. So this was the problem among the industry as well, that what should happen in case the first appellate authority drops the substantial amount of demand, not the entire order, but a substantial amount of demand, as was confirmed in the OIO. The first appellate authority is when drops a substantial amount of demand in OIA, what should be the amount of pre-deposit that we should make at the time of filing appeal to the GSTAT? I'll just take an example of this. OIA confirmed the demand of rupees 1 crores. OIO confirmed the demand of rupees 1 crore. Assessee filed a first appeal before the commissioner appeals, and by paying 10 lakhs as pre-deposit, and the commissioner appeals dropped that demand to say 15 lakhs. So 1 crore demand has been dropped to 15 lakhs. Now, assessee wished to file again a second appeal before the GSTAT against those confirmed demand of 15 lakh rupees, and GST amount, pre-deposit amount that comes out, 10% of 15 lakhs comes out to be 1.5 lakhs. Or if I take, say, 20% of 15 lakh comes out to be 3 lakh, but already 10 lakh rupees has been deposited in the first appellate stage when I filed the appeal. So whether I am required to again to pay 1.5 lakhs as pre-deposit uh, before the GST 80 before filing the appeal. So this case was discussed by the Katak bench of the GST 80 in the case of Manoranjan Das. The tribunal in this case has relied on the judgment of the Jharkhand High Court in the case of Messrs. Ashirwad Food Industries, which held the same as this, that the pre-deposit should be considered on the final amount confirmed. And if I take 20% of the 15 lakhs, that comes out to be 3 lakh, and the amount that has already been deposited, if it exceeds the amount uh, that is required to be deposited. So 10 lakh when exceeds 3 lakhs, then no amount of pre-deposit is required to be made while filing the appeal at GST 80 level. This was also held in this case, that no amount of pre-deposit is required to be made, since whatever the amount has been deposited at the first appellate level is already exceeding the amount required to be deposited in the second appeal. So, I mean, when we were filing the appeals, this was the confusion among the industry. This was, everyone was discussing that what should be the amount of pre-deposit that we should make when we have already blocked our funds at the first appellate stage, and 15 lakh rupees demand confirmed. Then also we have not been refunded the pre-deposit, maybe proportionate pre-deposit. What should happen in those cases? So now the clarity has been received from Katak bench of GST 80. I think all the benches will also follow the same approach, and we are not required again to make a pre-deposit if our already deposited amount exceeds the requirement of pre-deposit.
Moving on to the last, I would not say judgment because the matter has not been concluded yet, but there is a very big open issue right now that whether the tribunal can condone the delay beyond the stated time period of 3 months plus 1 month. So for that, the principal bench, Delhi principal bench, they have listed to all the appeals which have been filed before the GST 80 regarding this particular matter. So the for all the matters, the matter will be heard on 20th July before the principal bench. So just because this is a very important matter affecting a lot of appeals, so that is why I thought that I'll update everyone here. So I think that concludes our judgment portion. We also have some other updates apart from the judgments. So, Ayush, do you want to take that up or should I?
You can take that up.
So, first is regarding so few months back, the government mandated that ship to GSTIN provision on e-way bill portal, that when you have to generate e-way bill, you have to mandatorily give the GSTIN. So I think earlier that was supposed to be rolled from May or June. Then that was pushed back a few months uh, because of a lot of confusion in the industry. So now to address those confusions, the government has have came up with a lot of very detailed FAQs. So those FAQs can be seen by everyone, and if they so a lot of queries, I believe, will be solved from those FAQs. So you can see the FAQs on the GST portal. Second update is regarding aggregate annual turnover. So in everyone's DSA registration, aggregate annual turnover is reflected, which can be duly amended by the taxpayers. So they have amended the timeline for this year. So for the aggregate annual turnover, the assessees can amend the turnover from 1st July to 31st July. So till 31st July, we have the time to amend, and then that will be reviewed by jurisdictional tax officer from between 1st August to 15th August. So if there is any observation of the officers, he can raise that observation, or otherwise the turnover which is amended by the taxpayer, that will be considered as final. So it is going to be important for a lot of things, but primarily for considering the e-invoice threshold. So you have to be very careful. Everyone has to be very careful and check if they are nearing that threshold. And lastly, we have again, so this is a very, very important update. So the GS principal bench of GST tribunal, they have issued an advisory, sorry, they have issued an order. So because a lot of people were facing problems in filing appeals on 30th June, before 30th June, and the timeline has been extended by a month, but in recognition of the fact that still a lot of people may still face problems while filing the appeal, so the tribunal has came up with a token system. So basically, what the tribunal has said is, if you want to file an appeal, but you are not in a position to file the appeal before 31st July, so they will give an option on the GST portal to generate a token. So what the taxpayer has to do, that you have to fill up some basic details on the GST portal, giving reference of the order, and basis that a token will be generated. And once a token is generated, then within next 60 days, the appeal can be filed. So in that case, the assessee gets additional 60 days to file the appeal, and each token for each appeal. So if there are five different orders against which you want to file five different appeals, so five different tokens have to be generated. So each token for a different appeal has to be generated. I think that is it regarding the updates. So if any participant has any queries, maybe we can take that up.
Yes. If anybody has any queries, we can take the part. Mahendra ji has
Mahendra ji
raised
has
his
raised
hand.
his hand.
Mahendra ji, yes, you can please unmute yourself.
Yes, Mahendra ji, you can unmute and speak.
Am I audible?
Yes.
Actually, got a fund my dealer has filed CFP 08 for financial 1920 very late after 30 days. Then in on April 24, same dealer received a notice from the officer for delaying filing CFP 08, late fees and penalty. After replying, he had cancelled the demand of late fees and penalty. Now we have received EPF 03 for penalty that we have under section 73 for delay for paying late fee for paying the amount under CPG after 30 days. So is it allowed?
I I did not understand. Mohit, did you understand query?
I think so. Your voice is very low. I am also not able to hear properly.
Actually, you were audible in the beginning, but then your voice started, is
Okay,
very low. Can you please type it in the chat box?
okay.
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 Meanwhile, if any other participant has any query,
Hello,
Yes, sir.
uh, yes, Charanjit ji.
sir. I am audible, huh?
Yes, you're
Yes, Sanjay ji, you are audible.
Sir, good afternoon, sir. Actually, sir, we have received a notice from our client for 4 years for audit from CGST, sorry, SGST department, state authorities.
Hmm.
And can we challenge this notice, or there is a provision they are authorized to do audit for 5 years or 4 years, likewise?
Sir, on what basis you would like to challenge it as a notice?
No, I think it should be on for a particular financial year wise.
No, sir. See, if you will read section 65 clearly, sir. First of all, they have been given the power to do the audit.
Because
And
just a second, because sir, I have experience when the notice was issued under section 66 to clients. I know some
it's a
person,
special
some
audit, yes.
they have challenged this audit, particularly the 66.
So on what basis they challenge that it cannot be for more than a year?
Exactly, I don't know, but they have challenged it on
See,
some ground.
if I read section 61, 65 1 clearly for you, because right now, then you said it, I read it again. I'll just, quote it here also, just copy paste it here also. Just a second for the convenience of everyone. The commissioner or any officer authorized by him by way of a general or specific order may undertake audit of any registered person for such period as may be prescribed. So the word tax period, as we use the judgments of 73, 74, that a tax period has been written in it. It is written such period as may be prescribed. So according to me, they can issue a notice for any years as long as they are within the time limits of section issuing the notices under section 73 or 74. See, if they issue any notice now in today's date to conduct an audit of year 1920, then you can challenge that very well, that there is no time limit left to issue any notice or to recover any demand of that year. Or if they issue any notice after August to conduct the audit of 2021, then you can challenge that ADT1 on that basis. Otherwise, they are very well within their powers to conduct the audit.
Okay, no, they have
Mohit, do
issued
you have
from
any other?
21-22 onwards. 21-22 onward.
Okay. Mohit, do you
So
have
I
any
think
other?
on this basis only,
Okay.
then you cannot challenge, as
Okay.
Ayub
On the,
said.
on
But if they are not, if your jurisdiction is in center and state has issued, so on that basis you can challenge. So we have some on depending on facts of the case, we may be able to develop some grounds for challenging, but merely on this ground we will not be able to challenge that you cannot conduct audit for 4 years or 5 years at a time.
okay. The another question is, once the state authority finalize this period of audit, can there is a scope for central department also to do the same exercise for that covered period, or it is over and on some other grounds?
Currently, right now.
Once the state authorities have conducted audit for this particular period for 3-4 years, later on some other issue or some other ground or some other information, can central authority CGST department also issued the notice to same assessee for the period or the part of the period which is already covered by audit by the state authorities?
The law as it stands today. So currently we have one judgment of Supreme Court in case of armor securities, wherein because what Section 6 of CGST Act says, as to say CGST as well as all the SGST Act is, once a subject matter has been taken up by one authority, it cannot be taken up by another authority. Armor security, in case of armor security, Honorable Supreme Court held that by subject matter, the when the proceedings has been initiated for a subject matter. So what Supreme Court said is proceedings has been initiated means issuance of a show cause notice, and subject matter means a particular matter for the particular year. So as in essence, what Supreme Court said is, first of all, proceedings will only be considered initiated when a show cause notice has been issued. So if CDST department conducted an audit and they did not find anything, or they found anything, but you accepted and you paid, no show cause notice was issued, then
Yes.
SGST comes for the same period. So technically, as per that Supreme Court judgment, you have to get the audit done again. But strictly speaking, I believe that this particular matter was not discussed at length in that judgment. So we can always argue that once an audit has been conducted by one authority, it cannot be conducted by other authorities.
See
So
what
in
happens. Yes, yes,
hmm.
yes.
So in service tax, we had a circular governing even no interactions between different department of the same government. Like once anti-evasion is in the work, then audit department cannot go again to same assessee for the same period. But there is no such kind of circulars in GST regime, due to which a lot of these confusions are happening. But I believe if audit has been conducted once, then it cannot be conducted again. But we have to go to courts for this. At department level, it is very hard to substantiate this ground.
Okay. Sir,
Yes.
in one, may I ask one more question?
Yes, sir,
Ye-
please, please.
Yes.
Sir, in another case, there is a audit conducted by the department, and they raised some paras. Around 50 lakh demands was raised in different paras, and we are disagree from that paras. Particularly, there is a interest portion is major. So we are just replying that we are not agree from these paras. Now, the department, what is the in the hands of department of audit team? They just transferred our case to our assessing proper officer, yeah, our assessing officer.
Sir, they
What
will.
is the further course of action from the department? Because
So
we just
further course is
disagree.
that they will issue the show cause notice. They have the
Who
power
will
to issue.
who will issue the show cause notice?
Audit authorities can obviously issue the show cause notice, and then they will, after issuing the show cause notice, will transfer your file to the adjudicating authority, who will then call you upon for hearing and will take up that decision. Take up the decision on the show cause notice issued by the audit authorities. So there has been a circular, internal circular, some instructions by the department on the CBIC as well, that any authority conducting the any sort of investigation or something for the for any SSC, they can conclude the investigation, take it to a logical end. They can also issue a show cause notice, but then the show cause notice has to be compulsorily adjudicated by the proper officer only and not by anybody else. So audit authorities can issue a show cause notice.
To whom we have to interact, to our assessing authority, then their
Sir,
role.
after issuance of show cause notice, yes, they must write in that to whom you have to communicate, to whom you have to furnish the reply. They will write it in that operating para of the show cause notice, where they write that within these days you have been called upon to show cause as to why this should not be demanded or recovered from you. There they write that to which authorities you have to.
Okay, then all the document which are in our sporting, we have to produce to our assessing officer.
Correct, correct, correct.
So then the audit team role has, we have no interaction with the audit team from this after
Correct, sir. Then their
getting this
interaction will be
show
over.
cause notice.
Yes, yes, yes.
Okay. Thank you very much, sir,
Yes,
for
yes,
your
Ajay.
clarification.
Ajay ji, you can unmute yourself.
गुड मॉर्निंग सर, गुड आफ्टरनून।
Good afternoon, Ajay ji.
अच्छा, क्या कहते हैं, ये जैसे ऑडिट हो गई किसी साल की, अब उसके बाद उस साल ऑडिट होगी, ऑडिट फाइनल होगी, वो सरेंडर कर दिया, अब बाकी जीरो पे ऑडिट हो गई। अब उस साल से रिलेटेड और नोटिस दिए जा सकते हैं क्या?
Other notice regarding audit or
ऑडिट ईयर 22-23 की ऑडिट हो गई,
hmm
ऑडिट फाइनल हो गई,
hmm
और डिमांड भी फाइनल हो गई, जमा भी करा दी, सब काम। अब उसमें कोई इशू रेज करके दोबारा ASMT 10 वो करा जा सकता है क्या?
So there are two dimensions to this. So one is legal, one is practical. So strictly legally speaking, there is nothing stopping the department
अच्छा।
for doing investigation for the same period. So if the matter was covered in your audit, so let's say 2A, during your audit, there was a demand for 2A and 3B, and you paid that amount, then department issues a ASMT 10 for 2A versus 3B difference. Then that cannot be done because that issue for that year has been covered. But if department in ASMT 10 comes with a different issue, that 1 versus 3B difference, which was not covered in audit, then
नहीं,
legally
ऑडिट
speaking,
में
in my
कवर्ड
view,
था, और ऑर्डर में कवर्ड था, और मतलब जो रिप्लाई दिया उसको एक्सेप्ट भी कर लिया, लेकिन जो ऑडिट का ऑर्डर इशू करा उसके अंदर उसका कोई एक्सप्लेनेशन नहीं है, वो मेंशन नहीं है। मतलब जो इशू था वो ऑडिट के अंदर क्योरी में था, ADT 1 जो जारी होता है ना, मतलब उसमें था वो, अपन ने रिप्लाई दिया और रिप्लाई एक्सेप्ट भी हो गया।
Is it there in the draft audit report or final audit report issued by the department?
हेलो।
Hello, हाँ जी, am I audible? Hello,
हेलो।
हाँ अजय जी, am I audible?
हाँ, ऑडिबल ऑडिबल।
हाँ sir, I was asking whether this observation was there in the draft audit report or final audit report
आपकी
which is
आवाज
issued.
ब्रेक हो रही है सर।
Sir, I can hear Mohit clearly. I can also hear you clearly. Uh, can you hear
Sir,
me clearly, sir, Ajay sir?
Ajay ji,
हाँ सर।
yes, sir. Can you hear me or Ayush clearly?
हेलो।
Hello.
There is some problems at Ajay ji's end only because I can hear you clearly, Mohit.
Okay. So, Ajay ji, there is some problem
हाँ
at
सर।
your end. Kindly check your internet once.
ठीक है, चेक कर लिया, आगे आवाज आ गई।
हाँ सर, अब आ रही है?
हाँ बिल्कुल आ रही है।
Yes, sir. So I was saying that this observation, whether it was given by the department in the draft audit report or the final audit report.
नहीं, ऑर्डर ऑर्डर में उन्होंने कुछ नहीं लिखा। ऑर्डर में तो केवल उन्होंने वो जो लिखा, जो हमने एक्सेप्ट किया था, बस वो। मतलब वो स्पीकिंग ऑर्डर नहीं कह सकते, जिसको अपन स्पीकिंग ऑर्डर कहते हैं ना, कि हमने उन्होंने क्या क्वेरीज रेज करी थी, अपन ने क्या जवाब दिए थे, क्या उन्होंने एक्सेप्ट कर लिए, किस पे डिमांड निकाल दी, वो कुछ नहीं लिखा हुआ उसके अंदर।
So,
सिंपल जीरो
that
डिमांड का ऑर्डर हो।
that is because that is not supposed to be a speaking order. The speaking order
हाँ
comes
हाँ
after a show cause notice has been issued.
हाँ।
So, this is actually a very practical problem because we have also faced this problem for a lot of our clients.
हम्म।
So, legally, if you ask me, then department has the power to do so. Practically, what happens is if audit has been done and ASMT 10 comes later, so usually we first submit a letter to the department saying the audit has already been conducted. This is the copy of the EDT2. And basis
हम्म।
that letter, in most of the cases, so I would not say 100%, but in most of the cases, ASMT 10 is closed by the department. But if the department does not close, then legally it is very difficult to argue, especially after the judgment of Armor Security. Because Armor Security has clearly said that initiation of proceeding means issuance of show cause notice. So unless and until show cause notice is issued, we cannot argue that the proceeding was initiated by the audit department.
ठीक है सर, थैंक यू सर, थैंक यू।
Thank you, Jaji.
Uh,
Hello, sir.
Hello.
Sir, may I ask one more?
Yes, please, sir, please.
Uh, Sir, can you clear, sir, what is the current position of taking input tax credit regarding lift in the building? Second, centralized AC. As far as the centralized AC, in my opinion, I think we can take, but I am just want to hear it from you both. What is the current position, sir, regarding lift and regarding centralized office
Lift and
taking?
centralized AC.
Yes, yes, sir. There is a office, there is a centralized office, and there is a lift also in particular office. Regarding lift, I think in my opinion, I think we should not. But regarding centralized AC, we can take. But I just want to know here to use the latest position,
Uh,
whether I'm.
yes. So, Ayush, you are taking up or I should?
I was just reading the Mahinder ji's query. I did not listen.
अच्छा अच्छा
Sorry.
कोई नहीं कंटिन्यू so Charanjit ji, see, so if we see the definition of plant and machinery in the explanation given in section 17.5, so
Mhm.
plant and machinery they have defined as any equipment, machinery or apparatus. And if
Yes.
we see the definitions of these terms in, because these terms have not been defined in GST law, they have not been defined in any judgment given in GST law. But we have a lot of judgments of earlier laws. So either in excise regime, service tax regime, VAT, income tax, in a lot of judgments regarding these laws, these terms have been defined in a very broad manner. So, basis those interpretation, I believe that both lift as well as centralized AC, usually we call it as HVAC,
Mhm.
HVAC systems. So both these HVAC systems as well as lift should qualify as plant and machinery. And if once they qualify as plant and machinery, even if they are immovable, then also credit is available as per section 17.5 C and D. So I believe the credit can be availed for both these transactions.
Okay, I think, sir, there, but I not remember the exact the time, but I think there was some advanced ruling regarding lift. They have
Changes,
denied there.
if we start going into advanced ruling, so then you stop taking ITC altogether. Then you
Yes,
don't
you are
even take
right.
ITC for your inputs.
Yes, sir. Yes, yes, you are right. Okay, we should ignore the advanced ruling.
Because
But
advanced
department,
ruling, 90% of the advanced ruling are against the assessee.
but department is very opposite view. Okay, so according to you, we can take both for the
Yes,
both asset.
absolutely.
Okay, if I came to any judgment or any review, I will share with you, sir,
So, sir, come
regarding
again.
this particular point regarding lift. Because if
The
I came to
judgment,
some
see,
material
ju-
regarding this, so I will share to you, sir.
okay, definitely,
Yes.
Chandraji ji.
Uh, Let me just answer Mahinderji's queries. He has written it a long time.
Hmm.
So, Mahinderji, see, so what I understand from your query is your return was filed beyond 30 days and penalty under section 7311 was imposed. And on further replying to the notice, the penalty was dropped. So a show cause notice was issued, as I suppose, and the show cause notice was then dropped, and you have been given the benefit. Like DRC 7 was issued of nil demand. What happened was then the department filed the appeal in APL 03 under section 172 and saying that, whatever the appeal was filed, whatever the grounds the department took. So your question is that whether we can say that it is a change of opinion. Second is you are saying that we can say that amnesty benefit of under section 128 should be given as I was entitled to that benefit had the original order contained the penalty demand. And third is can I take the benefit of circular number 76 dated 31st December 2018. Uh, See, as far as your first query is concerned, that whether filing of APL 03 should be considered as a change of opinion, I'll say no, sir. It is not considered as change of opinion. Department is well within their power to file a appeal uh, against the order which has been dropped. So, see, all the orders are reviewed, and the commissioner or the person who has dropped the order is only authorized by the higher authorities to file an appeal against that order. So, even if the person who has filed an appeal, who has dropped the order, has again filed the appeal, then also you cannot say that this is a change of opinion. First, second, I think regarding the 128 section, I think you cannot take the benefit of amnesty scheme now because see, had the order contained the penalty and you would have taken the amnesty scheme is clear on its terms that any order issued before such date, I don't remember the date now, any order issued before that date containing the penalty amount or the tax amount, then only you are entitled to the benefit. And your that DRC 7 since was not issued beyond that date or issued beyond that date did not contain any penalty amount. So right now you cannot take that plea. You can just take a plea that that 128 was applicable and therefore I should not be the penalty should not be imposed on me, but you cannot go under section 128 amnesty scheme and say that I want to apply for amnesty scheme and a penalty should be dropped under the amnesty scheme. But yes, always you can take one ground that at that time amnesty scheme was applicable, and even if the penalty was payable, that benefit of amnesty, I would have applied for amnesty, and then that therefore that benefit of amnesty should be given to me in this appeal. I don't know how much that ground would work, but obviously you should take this. And thirdly, obviously, the best ground you have is about circular number 76, which clearly says that the maximum that the department can do is levy a penalty under section 125 because the tax and interest has already been paid after filing of return and late fees has already been paid with the filing of returns. Therefore, there are no tax demand dues and penalty under section 7311 should not be levied. So this second point of circular number 76, if I remember, all discusses that point. So I think I answered all your 3 points. In case you have any further query. My dealer has received a additive one for financial year 21 to 25. If they raised any demand for 21 and 22, can we challenge this issue as time issue? Sir, yes, obviously, see, if the department will raise any show cause notice for 21 and 22, then they will obviously have to issue a show cause notice under Section 74. The ingredients of Section 74 are that there should be fraud, willful misstatement, suppression of facts. Department has to justify those ingredients, has to bring out that how come there was a fraud. Merely by doing an audit, they cannot say that there was a fraud, because we detected that at the time of audit. They cannot say there was a fraud. So obviously you can challenge that show cause notice that ingredients of Section 74 are not fulfilled, and therefore Section 74 was not invocable, and the limitation and the time limit for issuing of notice under Section 73 is expired. They're asking for penalty. Sir, you can very well refer to circular number 76, sir. Okay. I think Ajay ji का hand पहले से raise है. If no other participant has any query, then we can switch off the session. I has already post one.
I think we can close.
So we can close the session. Okay. Thank you everyone for joining this 21st session organized by Team Anivesh on indirect taxes. Hope to see you again on next Saturday. Thank you very much.
Thank you, everyone.
Thank you, sir.